Welcome everyone to another holding court session. This is one of our virtual series featuring leading advocates, lawyers, and elected officials to discuss issues related to our courts, our rights, and our justice system. Thanks so much to our outreach team here at AFJ and to Daniel Goldberg, who is our legal director. We are all honored today to be joined by Senator Chris Coons from Delaware and member of the Senate Judiciary Committee. Senator Coons has been certainly on the front line week after week, fighting Trump judges. He has asked some of the most critical, thoughtful, and probing questions at these hearings, and has been a real leader in trying to defeat some of Trump's most egregious nominees. We are also honored to be joined by Professor Harold Koos. Harold Koos teaches at Yale Law School, where he's a former dean. He served as legal advisor at the State Department under President Obama, and is one of the leading experts on international and human rights. This evening, we will focus on Trump's assault on our judiciary, but more importantly, on the future and how progressives can take back our justice system beginning in 2021. We are optimistic. Alliance for Justice, through our Building the Bench program, on which Professor Koos serves on our advisory council, we're working collaboratively with the entire progressive community to identify a strong pool of professionally and demographically diverse individuals for consideration by the next president for judgeships. Because while Republicans done everything they can to capture our legal system, the reality is that the next Democratic president will have an opportunity to fill hundreds of judgeships. 62 Court of Appeals and 120 district court judges will be eligible for senior status in January 2021. And we are working to ensure that the next administration is ready on day one to appoint wonderful jurists. We'll have a conversation for 45 minutes approximately, and then open it up for questions with the audience. If you do have a question, please email rachel@afj.org. Again, rachel@afj.org. Our first question is to Senator Coons. We have to start here. This event occurs in difficult and challenging times. Our nation faces a health and economic crisis, and we've been reminded by the tragic murder of George Floyd and the scores of Americans across the country marching in the streets of the continual fight against racism. Can you speak to the moment, to the millions of Americans here in this country who are crying out for racial justice?
Well, thank you, Nan. Thank you to the Alliance for Justice for hosting us this evening, and thank you. I have a hard time calling you Harold Koos. Thank you, Professor Koos, Dean Koos, for all your terrific work as someone who has seen directly the consequences of having highly qualified, trained, skilled, available legal talent to bring with you into an administration. You've seen the consequences for our courts and our courts' decisions. So thank you, Harold, for being on with me this evening, and Nan for the leadership that you and the Alliance are providing. This is a moment where we are seeing the consequences, both of a long arc. You know, if you think about it, it was the brutal murder of Emmett Till and his funeral that sparked a decade of protests that really helped fuel a successful wave of legislative action here in Congress around the civil rights movement. There were lots of people who'd been killed before and after Emmett Till in brutal ways, who'd been lynched and who'd been victims of racist violence. But his particular death and the gravity and the severity of his funeral and his circumstances helped really light a flame that burned for nearly for more than a decade. And so too, one of the questions some ask, why George Floyd in particular, why this particular murder? Partly was that it was so cruel and public and relentless. Its violation of the most basic human standards so clear, and the ways in which it was a violation of the trust that should exist between law enforcement and communities so shocking that even though we can all repeat the names of a dozen other African Americans who've been brutally murdered, whether through incidents in public like Ahmaud Arbery or Trayvon Martin, not with law enforcement, but in circumstances where they had every right to expect to be safe, or in police encounters, whether it's Eric Gardner or Breonna Taylor or Freddie Gray. They are too many to name here, but I think what we're seeing right now, Nan, is the boiling up of a generation choking on the injustice in our system. And we're seeing this long festering wound of America's original founding sin of racism and slavery continuing, and frankly, in an environment where we have a president who does not unite us, but continues to crack open wider the divisions that in some ways have always been at the core of American society, that has helped accentuate it. So there is real excitement here in Congress about the Justice and Policing Act, which has been introduced in the House and Senate. I am an original co-sponsor. I expect that we will hear in both bodies a lot of commentary and engagement. We had a steering committee hearing here in the Senate earlier today where we heard from advocates and activists from Vanita Gupta to Reverend Al Sharpton, and debated and discussed the details of it. There will be a formal hearing in the Senate Judiciary Committee on the 16th. But I am concerned that it won't get a fair hearing, it won't get floor time, and it may not get a vote in the Senate, just as Mitch McConnell, the majority leader, has prided himself on making the confirmation of extreme conservative judges his principal goal. He brought us back from the pandemic, brought us back into session for the sole purpose of ramming through an unqualified young judge and acolyte of his to serve on the DC Circuit. So too, I think blocking progress is something in which the majority leader has taken some pride. He's actually announced himself as the presider over the legislative graveyard of the Senate. So in this moment, when you have literally millions of Americans and millions around the world mobilized by the death of George Floyd, it is my hope that this national surge of power and energy and engagement at the grassroots will actually overwhelm the resistance, the structural and too long-lasting resistance of the majority leader, and we might actually see legislative progress here in the Senate. We can only hope for that and pray for that and work for that. Again, thanks, Nan, for a chance to be on.
Sure.
Thanks for the hope that the Alliance gives to so many progressives around our country that we might yet have constitutional order in our courts and in our Congress and in our country.
Thank you. Harold, I was wondering, you've had so much experience with governments around the world, some run by autocratic presidents. Well, just last week we saw an attorney general lead an attack on peaceful protesters so that President Trump could conduct a photo op. We've seen the president conduct unprecedented attacks on the rule of law and make remarkable assertions of executive power. How do you put our country in some international context right now, given your experience?
Well, I think we're teetering. I think what was an extraordinary event of last week was that the president wrapped himself in religion, the military, and the rule of law to do something that was antithetical to each. Senator Coons is a master of divinity. You say love one another, not demonize one another. It's been a credo that civilian leadership does not send military generals to commit U.S. troops onto U.S. soil against U.S. citizens. And it's a First Amendment right to have the right of peaceful protest without being persecuted as if you were a criminal. So what happened was fundamentally anti the Constitution and anti the values of this country. But to focus on something that Senator Coons said at the end, he mentioned the kind of tidal wave. I think we should think back to the landmark civil rights moment. Starts in the streets, but then moves to all three branches. So you have judges, the unlikely heroes of the Fifth Circuit who played such an important role, then legislative action in the Civil Rights Division, and then an executive branch who can start by being a follower, the Eisenhower administration, and then take an initiative. And then that is the kind of thing that actually brings meaningful change. And I think what we want to remember for the purposes of this call is that someone like Thurgood Marshall, who began as an advocate, or his colleagues, Constance Baker Motley, or Spotswood Robinson, or Robert Carter, they all got nominated. They all went onto the courts. And these were people for whom this was a basic credo of how they had come to see themselves as lawyers and defenders of the Constitution. And I think that's one of the messages that we should take away. The Justice and Policing Act is going to be hugely important. The actions in the streets are hugely important. But what happens in the courts, if, say, the Justice and Policing Act gets challenged, will turn on who the judges are who have been appointed. And it will bring on the cases that will be brought. And will this be accepted as law, or will it be challenged as the Affordable Care Act has been from day one?
Yes, Senator Coons, I want to spend our time talking about the future, but to talk about the future, you have to look back to the past as well. The reality is that the president and Mitch McConnell have prioritized the courts in an unprecedented manner. They've succeeded in putting on the benches, you know so well, ultra-conservatives, largely white and male, devoted to advancing partisan policy agendas that conservatives can't enact through the democratic branches of government. So they're now sitting on our courts. Can you describe the erosion of norms you've seen in the Senate and the type of judges that have come before your committee who will now be deciding cases for really decades to come?
Well, if you look at who's been confirmed and how, you're absolutely right, Nan, that it's been striking how many of them are very conservative, have long records of public statements that are often well outside the mainstream, and have decisional records or jurisprudential views that are well outside the historic mainstream of American legal thought. We've had more folks brought forward as judicial nominees who've had a judgment by the American Bar Association that they are not qualified than ever previously. When President Obama was in office, he did not nominate a single judicial nominee with an ABA not qualified rating. If you look at the two who are one's before us, one's just been before us, Justin Walker for the DC Circuit and Corey Wilson for the Fifth, they're very young. They have very limited experience in the courtroom. They have distinguished themselves, if you would call it that, really by their virulent opposition to the Affordable Care Act. They're being elevated to critical circuit court positions, not because of their credentials and skill and experience in the courtroom, but because of their partisan position on one specific issue. And I've spoken out against them, voted against them, worked to help lead opposition to them. There are many others we could talk about. One who was particularly egregious was Thomas Farr, nominated for the Eastern District of North Carolina, who had demonstrated skill in voter suppression and in crafting and carrying forward and carrying out with, I think as one federal court opinion wrote, surgical precision, efforts to sustain voter suppression efforts against African Americans and other racial minorities in the state of North Carolina. His nomination was ultimately successfully withdrawn after just enough Republicans were convinced that he was not appropriate to serve on a federal district court. But if you look at the two Supreme Court nominations that I've had the challenge of participating in or sitting through, in both cases, Neil Gorsuch and Brett Kavanaugh, now Justice Gorsuch and now Justice Kavanaugh, there's a common thread across both of them, which is extreme views on executive power. And in the dance of the Constitution and in the structure between the three branches, both of them have opinions, both expressed in speeches and in written opinions as sitting circuit court judges, that embrace a theory of executive power that I think is not just well outside the mainstream, but borders on dangerous. So to your last question, to Professor Coe, to Dean Coe, how the next actions by President Trump are reviewed by the Supreme Court may well turn on the view of executive power held by this Supreme Court. And I'm gravely concerned that they will be making significant shifts in the balance of power between the executive and legislative. We had an oversight hearing earlier today with the SBA administrator and the Secretary of the Treasury, where, as has happened across so many different issue areas, I raised, as other senators raised, a lack of transparency, a lack of responsiveness, a lack of answers to questions for the record. And in many settings, in too many settings, the current administration has simply dismissed with the back of a hand requests from Congress. They've dismissed inspectors general. They've dismissed existing guardrails. We've seen too many norms brushed aside by this president, and that shocking display in Lafayette Park and his striding across a newly cleared of noisome protesters, this park dedicated to liberty, to stand for a photo op in front of St. John's Episcopal and awkwardly waving upside down a Bible, was just the culmination of what I think is a very troubling trajectory on our courts.
Well, I would certainly thank you for raising the issue of executive power at Senate hearings, particularly with respect to Kavanaugh's confirmation. Judge Wilson was being reported out today. Corey Wilson for a seat to the Fifth Circuit Court of Appeals. And I know that he's made many statements on voter identification laws. Was that a factor in your decision to oppose his nomination?
Yes, there's a variety of things in his background, in his statements, in his activities that I saw as concerning, but a persistent refusal to recognize, embrace, and engage with the access to the ballot challenges of voter ID laws, the ways in which they've led to voter suppression, and frankly, the historic nature of the seat which he will soon hold in the Fifth Circuit. Dean Coe referenced the critical role that was played by his predecessor in that Fifth Circuit seat in terms of rendering decisions, taking actions using the power of the federal judiciary to ensure, for example, that the march from Selma to the state capital of Alabama proceeded successfully and safely. That someone who has acted not to protect the right to protest, not to protect the right of access to the ballot, but instead to suppress the power of voting, which is that most foundational power in our society, that he would hold that seat struck me as particularly offensive.
Professor Coe, we saw during the 2016 presidential election that wherever Donald Trump went to campaign, he talked about the Supreme Court over and over again. And we also know he did it because he was hoping to galvanize the right-wing base in this country, the evangelicals in this country, to come out and vote because they care passionately about the courts, or maybe care passionately about overturning Roe versus Wade. Given your work in law schools, your deanship, your work at the State Department, how do we encourage progressives to care as passionately about the courts as their counterparts on the right? What's your thought about that? Oh, I think we have to unmute you, Harold.
Sorry, can you hear me?
We can hear you. Start over.
What I think the last few years have shown is how much the Supreme Court matters, and even just a fourth and fifth vote. And in fact, the Supreme Court is one reason why many people who do not like the president's personality or other behavior continue to support him. But I think we couldn't have a more graphic illustration of the way in which 5-4 majority can have influence down through the system. So what has happened increasingly, starting with the travel ban decision, when the court accepted what Justice Sotomayor called the national security masquerade, the Solicitor General's office at the Justice Department has essentially changed their strategy. So they try to get everything to the Supreme Court as fast as possible. If a lawsuit is brought, for example, an immigration case in the Ninth Circuit, and they lose at the district court on a preliminary injunction, they just skip the circuit court and go straight to the Supreme Court and try to get it stayed, which is often done with little or no consideration. For example, the Ninth Circuit had struck down an immigration policy of the US government as an asylum ban that they said was illegal. And then a couple of days later, the exact same ban was put into place. The one had been declared illegal under the guise of being a public health measure with regard to COVID-19. So it's very clear that the composition of the court is huge. Now, Chief Justice Roberts likes to say, I'm just an umpire, but we all know that every umpire has their own strike zone. And it's not just whether these justices are prepared to strike down laws like the ACA or to keep challenges open, but it's also the whole way they address issues about whether cases can get into court and be decided on the merits, who has standing, whether they're ripe or moot, whether they're political questions, is there equitable discretion to hear the case? And through all of these devices, many of them supposedly procedural, the Supreme Court can influence outcomes. Well, let's just take a very simple example. In March, early March, coronavirus hit. Every single entity in the country shifted to Zoom technology within 2 or 3 days. The Supreme Court, in the name of tradition, refused to hear cases for 2 months, and then only then decided that they would hear them on audio in the name of preserving tradition. But what happened in the meantime? Cases like the case about the congressional subpoenas for Trump's tax returns and other records didn't get heard, and they won't get decided. That's essentially a substantive ruling that was issued by delay and using procedural tools. So I think that the composition of the court, the Supreme Court, is a gigantic issue. Hopefully we have a stable composition between now and the election. And it'll be very important to see what happens there in the future.
Thank you. Senator, I know that you have worked, have you worked tirelessly to persuade your Republican colleagues to reject judges? For example, someone like Stephen Menashe, who was confirmed recently to the Second Circuit Court of Appeals. It's interesting to note that Lisa Murkowski was quoted during the Menashe vote that she was reluctantly voting yes, but was being, quote, hung out to dry, close quote. Why have Republicans been so willing to acquiesce to some of these almost comically unqualified judges?
Well, Nan, I just briefly suggest three different reasons. One is that their base is relentlessly focused on the federal judiciary in a way that, frankly, ours has not been. There has not been this urgent sense of disconnect between our view of the world, our priorities for the activities of Washington, for how our society should be ordered, our constitutional jurisprudence. Is not as, there has not been a building and structural sense of misalignment between our values and the actions of the federal courts for 40 years, and the way there has been for the far right. They have had a structured, intentional project since my days in law school to build and deliver a conveyor belt to train and lift up and to apprentice and to manage and control and then deliver judicial nominees whose ideological purity and fervor can be attested to. So why would a senator like Senator Murkowski, someone who's often open-minded, willing to consider alternatives, be so dedicated to this? First, because the Republican base, and in particular the parts of the Republican base that made it possible for Donald Trump to win the presidency, have focused on it relentlessly. Second, it's something Mitch McConnell has focused on relentlessly. So if you want to pass other legislation, if you want to get other things done, if there's other priorities that you place a higher priority on than the courts, you acquiesce if you're in that caucus. And then third, Donald Trump, President Trump, is perfectly clear that he would not be president without the buy-in of the religious right that made his list of Supreme Court picks, his outsourcing of the selection of Supreme Court justices and all federal judges to the Federalist Society, the deciding point, a linchpin point in his presidential campaign. So judges and their central role in the conservative project of realigning the relationships between sort of liberty and order, between the federal government and our states, there's so many different substantive ideological efforts underway at the same time here. Someone like a Senator Murkowski and many others acquiesce in allowing the moving ahead of one or two or three judges who they consider objectionable. But frankly, that's not what brought them here. It's not what they're concerned about day in and day out, but it sure as heck is for the presidency and the White House, for the majority leader, and for a wide range of folks who frankly are contributing massive amounts of money to secure a conservative federal judiciary.
So, Harold, we have a lot of people on this call who have argued with Democratic administrations, advocated, gone to meetings in the West Wing for those Democratic administrations to prioritize judgeships. The next president will face a whole lot of issues. We certainly saw that with President Obama. Coming in his first year, he had to deal with an economy that was not in good shape, and a whole slew of other issues. How do we get the next president to prioritize the judiciary and appointing judges?
So I think it comes from the base. If one side's base persuades their president that judges are important, so can the other side's base. And the way that it gets done is to create a focal point. There has to be someone in the White House who wakes up every morning and says, I'm going to get this judge through today. And that's going to be the only thing I work on, and gets it done. And if you don't have that focal point, then there's nobody driving it. Secondly, I think you need a pipeline, and I think that's what the Building the Bench program of AFJ is helping to do. Third, I think you need to bring in trustworthy validators like the American Bar Association. You know, if you make the only validators people who are checking for political ideology, then that's all you get is political ideologues. I think that the vetting process needs to be thought through carefully. You don't want it to be sloppy, but it can also spend too much time on the small stuff. And I think you should pick people with strong, reasoned records. one thing about the Trump administration, they haven't been afraid to put on people who have strongly expressed very negative views. It's not clear why the next administration should put on people who have expressed no views in response. They should pick people who have taken strong positions and argued strongly for civil rights, Thurgood Marshalls of their time. And then finally, they have to be prepared to fight. You know, in the last couple of Democratic administrations, in early controversies that went to confirmation, the administration backed off because of its other priorities, and that sent a message. And I think you have to be willing to fight for and willing to fight against. You know, when you defeat Carswell, then you get Hainsworth, you get Carswell, and if you defeat him, you get Harry Blackmun. If you defeat Bork, you get Ginsburg, and then if you defeat Ginsburg, you end up with Anthony Kennedy. The fight is worth it. And then if you fight to get someone confirmed, like Nancy Gertner, that person is on expressing a very different view. So it's not enough to just put names up there, and then if people object, to just pull those names. You have to be ready to go to the mat for them.
I think that's absolutely right. Do you think the previous two Democratic presidents could have done better?
I think the thing that was missing was the focal point. You need someone very high inside the White House whose job it is to do this, and who has enough sway that they can mobilize all the different branches of government and reach out to people in the Senate, like Senator Coons, and you know, get this process moving. And these things build their own momentum, and they also, if they start to stall, they stall in the same way. And I think that's what happened. Is we would be tracking the particular nominations, and they would sit there for months, and it would because one senator lodged an objection and nobody was willing to go and engage that senator and get that person's name off the mark. You know, I was unanimously confirmed in '98. And then after I was dean of Yale Law School, that was obviously disqualifying. And my next time up, I was held up for confirmation, not for a judicial appointment, but for 3 or 4 months. And at the end of the day, it was only because certain people fought for me, both on the Senate and in the executive branch, that I got confirmed in the first place.
Nan, I've got a lot of painful experience in this exact area. One of my good friends from growing up from Delaware, who was Thurgood Marshall's last clerk on the Supreme Court, Harvard Law School graduate, very accomplished, worked actually in the legal advisor's office in the State Department, was nominated for an ambassadorship to UNESCO, and ended up hung out to dry for 18 months and being fought and took a great deal of effort to get that particular confirmation through. And there are so many other stories we could spend people's time going through. I chaired the subcommittee on courts early on in my time in the Senate on the Judiciary Committee. And I was enormously frustrated at exactly the dynamic Harold's describing, where there was just sort of sideways movement, dithering, and frankly, half of the vacancies that got created, to just give you a rough number. We could have been more aggressive at clearing them, vetting them, getting them to the floor while we still had the majority. I think part of the problem we had was being less relentlessly focused, because we didn't realize that we might well lose the majority soon. That won't happen again. If we have a Biden administration, there will be in the White House someone who previously served as the chairman of the Judiciary Committee. I certainly, and many others here, have had the painful experience of being in the majority and the minority, and of having a majority leader and a minority leader who were very focused on the federal judiciary. I think you can count on me and many others to be relentlessly focused on making certain that we fill vacancies as soon as possible, as responsibly as possible, but with nominees who have appropriate, well-grounded, strongly held views on jurisprudence, and who will contribute mightily to the advancement of justice on the bench.
That's Wonderful to hear. Following up on that, Democratic presidents, as you know, have faced unbelievable obstructionism from Republicans when it came to judges. Just look and see what happened to Merrick Garland, who never even got a hearing or a vote. And I remember the last year of the Obama administration that dozens and dozens of well-qualified, extremely well-qualified nominees never got hearings by Mitch McConnell. Republicans have changed many of the norms that they successfully used during Clinton and Obama's administration to ensure expeditious confirmation of Trump judges.
Yep.
Do you support bringing back many of those norms and rules?
Look, first, I'm not going to get into specifics about exactly what we might do in the majority, but one of many norms that has been repeatedly and flagrantly violated on the Judiciary Committee is the respect that we showed in the majority for the blue slip tradition on circuit courts. As a number of us cautioned the chairman, violating that tradition so flagrantly in these circumstances that produces a number of the nominees we've talked about is something that won't soon be forgotten or reversed. Look, the larger level problem we've got is that the confirmation process has gotten more and more broken and dysfunctional. But speaking for myself, I can't imagine why I would agree to allow a Republican, either majority or minority, to hold judicial nominees and create a whole generation of vacancies and block the administration's prerogatives and agenda for the courts if we are so fortunate as to have the majority again and to have the White House again. I'm going to be pressing for us to confirm highly qualified, highly capable judges at as fast a clip as we possibly can.
Great. Harold, anything to add on that score?
Yeah, I think that there have been some bright spots even in this bad story that we've recently faced. For example, when a state has two Democratic senators, sometimes they've been able to put together an agreement. For example, some of the judges in New York have been quite good. I know that Senator Coons did that and got back into a kind of a less partisan way of picking judges. And one question really for Senator Coons is whether it's possible to recreate that if someone has a certain level of qualification, that even if you don't necessarily believe what they believe, you will support their confirmation in exchange for someone of similar qualifications on the other side being confirmed. And that used to be quite a norm in this process, and it seems to have gone away. I clerked for two Republican judges, Justice Blackmun, who was a lifelong Republican, Judge Malcolm Wilkie, who was a Republican judge. And when I met Judge Wilkie for my interview, he said to me, "I will never ask you two questions. One, your religion, and the other, your political affiliation." Now, the prime question is, are you a member of this organization or that organization? In other words, you have to accredit yourself through your political ideology, and that's what our students today face.
Forgive the distraction, Nan, but I just have to say, unlike Professor Coe, when I interviewed with Judge Roth on the Third Circuit, we had a wonderful and vigorous conversation. She's an amazing and talented judge, and I was really grateful for the opportunity to serve as her least qualified clerk. But after what was a very warm and positive interview, she said, "Is there anything you feel like you have to tell me before I consider your," and I said, "Yeah, I just have to admit that I actually worked on your husband's opponent's campaign for the Senate." And there was this long silence. And she looked at me and she said, "Then I hope you're a better law clerk than you are a politician, because my husband beat your candidate's behind,
Right.
very. And she made a point of having in her chambers at least one clerk per cycle who she thought came from a different tradition or view of society or jurisprudence to test her and challenge her, and she welcomed that. In fact, she celebrated sort of vigorous debate in chambers, and to the point made by Dean Coe, in Delaware 3 years ago now, 2 out of our 4 district court judges came to me and to my senior senator, Tom Carper, and indicated that it was their intention to retire soon. And we were able to work out, now these are district court, not circuit court seats, but we were able to work out with the White House counsel at the time and with the Delaware Bar, a process where we interviewed and vetted and ultimately provided blue slips for 2 very capable judges. One a lifelong Democrat, one a lifelong Republican, but the sort of highly qualified, nonpartisan judges that would have been much more typical a decade ago. And it worked out in the way that Harold's describing. There have been a number of other encouraging recent instances where states, as he says, with 2 Democratic senators have been able to advance nominees. I am close to one nominee who was nominated by Obama and has been re-nominated by Trump and re-nominated by Trump. But one of the things I wrestle with is folks who question my voting for so-called Trump judges. Several of the nominees I'm referring to who were nominated by Obama or who got blue slips by 2 Democratic senators do not fully hearken to, these are not acolytes of a Federalist Society ideology simply because they were nominated while President Trump was in office. And at the district court level, that still pertains. At the circuit court level,
Right.
virtually every nominee has been a disappointment, either in terms of the decisions they've made once confirmed or in their qualifications and process of confirmation. And I have voted against the overwhelming majority of the circuit court nominees, but I have voted for a number of district court nominees who I thought were qualified and who were folks who should not be barred from serving simply because of the president who nominated them.
We'll excuse your vote for that because you're right. Some of these district court nominees have been really very well qualified. So we talked earlier about differences in the bases, caring the progressive base versus ultra-conservative base, caring about judges. And we really have seen progressives galvanize. Senator Coons, with Stephen Menashe, 100,000 teachers sent in letters and emails, were incredibly active. How do we get our leaders to realize that our base is energized and does care as much about this issue as their counterparts?
Well, the Menashe nomination was a high watermark in terms of the engagement, the visibility of it, in terms of our opposition to it. One of the things that I spoke about before, but I think is worth reminding everyone of, is that the intensity and the sustainment of that level of engagement has been consistently so much greater on the right than it has ever been on the left. Now that we are in a place where the federal courts have a significant number of very conservative judges and the Supreme Court has a conservative majority, I am sad to say I think there will be more and more moments in the future where progressives will see the federal courts acting as a barrier to progress rather than as the floor or the support for progress. And I think that will lead to more sustained engagement in the future. Our caucus leader, Minority Leader Chuck Schumer, is well aware of the mobilization, in particular around the Menashe nomination. But frankly, we need it to be more. We need it to be more sustained, and we need it to be at all levels because we are losing in some critical states judicial elections, and we don't yet have the sense of an enduring and burning passion at the grassroots for the federal judiciary to be a central and defining issue in national elections. as Harold, as Dean Coe referred to previously, you know, you're going to get into moments in a new administration where you've got other fights, you've got other priorities, and you have to be willing to stop everything else, bear down, and fight your way through it, and not get distracted onto other priorities. I am encouraged by the fact that we've got several very capable senior leaders in the Judiciary Committee, in our caucus, in the Senate, who have lived through this harrowing and difficult period, who see the consequences already. Senator Whitehouse has been a very persistent and engaged and effective advocate in putting in front of our caucus the scorecard of how many 5-4 decisions have there been, and how do they align with corporate interest, and pressing the question over and over about dark money and how it has financed these campaigns for judicial confirmations, and the ways in which it is going to deflect the arc of progress for decades to come. Nan, that Menashe nomination fight was an important one. The fight over the Affordable Care Act has been a very important one in terms of mobilization. But frankly, we're going to need more sustained engagement, even though I'm very optimistic about the next administration and about the majority here in the Senate.
Harold, do you want to respond? If not, I'm now getting questions from the audience. So if people have questions, please feel free to send them to rachel@afj.org.
Well, I just add that an extreme confirmation does have the consequence of legitimating what would otherwise be illegitimate arguments. You know, take a look at the case about whether they can drop the charges against Michael Flynn. I think, you know, the average lawyer, a huge number of Justice Department former officials think it's obviously absurd, yet an extreme judge on the DC circuit, joined by one other colleague, entertained an appeal on a motion for mandamus. And now you have a former federal judge representing Judge Sullivan defending this action as if something wrong happened. And on the Affordable Care Act, the theory under which they're challenging this would jeopardize all legislation in which one tiny provision were declared unconstitutional on the grounds of inseverability, which would make it virtually impossible for Congress to pass comprehensive legislation. So appointing extremists bears fruit down the road. And so I think that it's very important to make sure that we're appointing people of genuine qualification. You know, someone like Merrick Garland, it's hard to think of whether we ever had a more qualified person just on the merits. And you just have to look at him, his ability, his record. And on that alone, it should have been enough to hold hearings and confirm him. And I think everyone privately admitted that this was true. He was not confirmed for one reason only: the party that he was affiliated with.
Yeah, no, absolutely. You know, it's interesting. We've long described, and we tend to describe these Trump judges as conservative, but Trump's judges seem to put that label to shame with their latent racism, their authoritarian views, with their antipathy to the Affordable Care Act. We just saw, and we're seeing, Walker and Wilson, who confirmations are being considered by the Senate, refer to the Affordable Care Act as perverse. If their views become law, we could see millions of Americans losing their health care. How can we paint a clear picture of just how extreme these judges are and nominees are?
Nan, was that a question to me or to Harold?
To you, Senator.
Thank you, Nan. You know, I like to think we do that job on the Judiciary Committee with every confirmation hearing in going over and over the reasons that we are voting against them. But one of the challenges is the limited audience that's actually watching. I recognize C-SPAN is not riveting for most people. This is why we need the Alliance to amplify, to engage, and to focus. Because, you know, look, it is different different reasons across different judges, whether it's their writings, their decisions, their affiliations in terms of organizations or priorities that they've advanced. But it is striking how many of the Trump administration's nominees for circuit court positions have a combination of being very young, having expressed very extreme views, having made fierce and firm and aggressive partisan positions part of their record of work, and as I referenced before, in a number of cases, having been determined by the American Bar Association to lack the relevant qualifications, whether it's district court experience or it's other qualifications for service on the bench, such as temperament. So, you know, I think for folks who don't follow this closely, for the average voter, it's all a piece of what the Trump administration has been doing in terms of violating traditions and guardrails in lots of different ways. You know, this is the administration that fired more inspectors general in a shorter period of time than any in history. But for folks who aren't lawyers and who don't follow, you know, the independence of the branches and the interplay between them and the balance of power, it is hard to make the case. I agree.
You know, this is Harold. We see more and more newspapers laying off reporters. And I'm wondering, and there used to be many, many reporters covering legal affairs for big national newspapers and local newspapers. How do you think about the press? Could they be doing a better job, even the fewer number of reporters there are, in covering what courts do, but really bringing home to people how harmful decisions are to their lives and the lives of their children and grandchildren? What's the role of the press in all this?
Well, the role of the press is huge, and I think we still do have outstanding journalists and outstanding coverage. The problem is that there's a lot of noise, coverage, which is actually advocacy on the other side, without much focus on the actual legal issues or constitutional values that are at stake. And I think that your audience can focus in on what it really means to have a rule of law. One thing is, you know, respect for precedent. So someone like Justice Souter, a Republican, voted against overruling Roe versus Wade on the grounds that he thought that the principle of stare decisis should stand. And that ought to be something that people are actually asked to live by. Second is, you know, Senator McCain drew respect in his waning days for his call for regular order. And if courts are doing extraordinary measures to disrupt things below, granting stays, reaching down to the lower courts to take cases, that's not regular order, and we ought to be very skeptical of it. And third is separation of powers and the balance of the branches. You know, President Trump has an extremely, well, we don't know whether he's read the Constitution or understands it, but what he does have is an extreme view of executive power.
Yes.
And so he likes the things that he can do that he thinks he has exclusive power to do, like pardon people. And in this, he has included things like taking away people's press passes, or now that he can terminate any international agreement at will, like withdrawing from the World Health Organization, which was actually an organization that during a pandemic, and this is an organization that we entered with a congressional statute. So interestingly, the press pass issue, a majority of the DC circuit a few days ago said, no, that's not his exclusive power. You have to consider the press's role in this. And I think it's very important for the press to push, for the courts to push back on the separation of powers principles, and if they're not living up to them, for the media to note the ways in which they're not living up to these things. In many ways, we have more coverage by podcasts, blogs, and other things, and I think that those can be compensating. But I think the main thing, again, is to have validators of who's actually making legal arguments versus who's engaged in demagoguery.
And Senator Coons, any thoughts on that and the press?
Look, I'll agree that it's the press has been fundamentally changed in the last decade. It is disaggregated from what it may have been 20 years ago. But we do have some really insightful, capable, powerful legal journalists. Some of them are now producing content online or for podcasts. It's distributed in different ways. But if there are ears to hear, there is a story being told. And it is possible to separate the wheat from the chaff and the noise from the signal. Dean Koos shared with me that analysis about why President Trump's unilateral attempt at withdrawal from the World Health Organization isn't legal, that it's not a power that he has. And we've seen some heightened and sharpened analysis of the things that he has been trying to do that are outside the realms of proper executive authority that have been well written, have been insightful, and I think have moved people in recent weeks, but over the arc of the last 3 years. An awful lot of the fight around the Trump administration and President Donald Trump's initiatives has played out in the courts. And there's been decent and solid journalism helping folks understand that a nationwide injunction, for example, may be the only way to push back on the harmful and the unconstitutional impact of a religiously based travel ban, for example, or that an injunction is a critical tool for questioning moments of executive action for which there will be irreparable harm. This is language that isn't common dinner table conversation for most American households, but some of the excellent journalism of the last 3 years has elevated it to that level.
Thank you. Well, the hour is drawing to a close, I see. And Harold or Senator Coons, either of you have any final statements you wish to make? And if not, thank you both so much. Anything you would like to close this session with?
Nan, I will give Harold the prerogative of closing. I was sharing with a mutual friend the other day that it was literally sitting through one session of his international business transactions course, literally, that persuaded me to go to law school at Yale. He was one of the most compelling professors I've ever had at any school in any format on any topic. And his leadership around human rights and democracy has left a remarkable legacy so far. And I know he has a great deal more to contribute. And his advice and encouragement and mentorship has meant an enormous amount in my legal career and now in my service here in the Senate. Nan, for everybody on the call, let me just simply say briefly that if you've ever wondered whether we are at a turning point in American history, in American constitutional history, in America's fight to become a more just nation, in America's place in the world, this is absolutely it. Harold and his family came to the United States as political refugees, and I've never forgotten the stories that he told us now decades ago when I was a student about how seeing our society and our country fight for democracy and fight for the rule of law challenged and inspired him as a young man. I've been to 83 countries. In my service on the Foreign Relations Committee, I have visited with authoritarians and autocrats, dictators, and terrifying leaders of obscure countries where their constitution on paper sounds and reads as well as ours, but the experience lived in the daily lives of their citizens is a nightmare to which I hope we will never submit. If you question whether this is a moment that's worth fighting for, whether this country and our Constitution is worth fighting for, don't question. This is a moment to fight, to work, to lead, and to bend the arc of history, which will only happen if we put our hands to that task in the elections that are upcoming this fall. Thank you, Nan.
What lovely words. Thank you so much. Harold, can you beat that?
No, I can't. So let me just say how proud I am of Senator Coons. I could tell as many stories about what a remarkable young lawyer he was and how proud we are of him every day in speaking up for American values and speaking up for constitutional values. And it's a pleasure to turn on the TV and see someone who's speaking substance and speaking intelligently and leading in a time when we need leadership. And thank you, Nan, and your organization for your leadership as well, and everybody who's on the call.
Well, thank you both so much for what you're doing for all of us in the country. And thank everyone on this call for spending this hour with us at Holding Court. We so much appreciate you as an audience, and we look forward to some more Holding Courts. But what a treat it was to hear from you both tonight. Thank you so much. Stay safe and healthy, everyone. Good night.
Thank you.